delivered on 30th January 2025. The committee has reviewed the bill's proposals on military justice and court-martial framework. The findings reveal concerns about compliance with constitutional principles, judicial independence, and administration of military justice. 6.1.1, the trial of civilians under military law. Clause 29 and Clause 30 of the bill address individuals under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all Defense Forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the Defense Forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of Defense Forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the Defense Forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offences. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the court. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces, in consultation with the High Command, to assign an acting rank to the head of the General Court Martial when the accused has a higher rank. While intended to maintain order, this mechanism may introduce bureaucratic delays and allow manipulation of the justice process. For instance, the Chief of Defense Forces could delay rank assignment impeding the prosecution of senior officers. The temporary rank, with its associated privileges, may also incentivize judicial officers to prolong proceedings to retain benefits, hence compromising timely and impartial justice. The committee therefore recommends that the proposals contained in the bill regarding composition and structure of the military courts should be supported, albeit with amendment to engender fair trial provisions as proposed in the committee's amendments. Appointment of the presiding officers and members of the courts martial. Right Honourable Speaker, the committee notes that Supreme Court emphasized that military courts, despite being specialized, exercise judicial power and must therefore uphold the same safeguards of independence and impartiality guaranteed under Article 129 of the Constitution. While the bill...
129 or 128?
I beg your pardon. Guaranteed under Article 128 of the Constitution. While the bill amends qualifications by requiring legal training for the presiding officers, committee expressed significant concern over the appointment process. Currently, all members are appointed by the High Command from a list it generates in consultation with Judicial Service Commission. This system grants the High Command broad powers to appoint members for specific trials, raising serious doubts about the members' independence and vulnerability to external influence. The idea of consulting Judicial Service Commission does not explicitly define the role of Judicial Service Commission in the process of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure